Good morning. Since holidays are being approached, there is possibility of every trial being adjourned after vacation. So I thought it is far better to discuss with you about how to conduct criminal cases. First, you must understand that for every crime there may be some background, motive, preparation, inducement, conspiracy, everything will be there. Uh, Once summons are issued after being released on bail, when they were arrested and all are granted anticipated bail, forget about everything. On appearance of summons, you will be furnished 207 copies of the final report filed. It is not charge sheet, it is final report filed by the police. See, actually earlier there will be a copy section which the typeset of final report and served the copies by the court itself. Nowadays, for convenience sake, the judicial magistrate are directing the police to prepare xerox copy, though they are serving the copies mechanically without verifying whether the actual or final report was served to you or not. So that you have to check it. Then at the time of framing of the question of framing of charge, or if it is triable by summary procedure, a questioning will be there. So before that you go through the final report. Three aspects you have to verify with the court records when you are served with the copies. Number one, the date and time of FIR registered and when it reached the court. Number two, when 162 statements are recorded and when it reached the court. Normally, investigating officers adamantly not giving date of their statement date when they have recorded the statement of witnesses deliberately in order to get rid of certain questions being put by defense counsels. Third one is, if it is hurt cases, kindly go through the accident report. Even in murder cases, when the deceased are being brought dead, there may be an accident report. The accident report may contain death report that brought dead, and you can get some particulars of time of body being to reach the casualty medical officer and the person who brought the body. That plays vital role during your trial. Or if he is a victim, alive victim, then when he was brought to the doctor, brought by whom, whether police accompanied him or he went. If that would be the case, you can very well presume that whether the FIR is anti-timed or antedated after recording accident report or after accident report, the FIR is filed or not. But in the accident report, there may be only identified persons, known persons, or only their name should not, may not contain in the accident report. That is the medical code guideline for the doctors. Place of occurrence, suggested weapons, time of occurrence, everything will be there. And particularly, the patient is conscious, answering to the question must be, if there was available. That means the statement recorded in the accident report was recorded by the doctor on oral instruction, oral information of the victim. That is most important. These all are the vital area where you have to concentrate. Then you must know that 161 statement are not be treated as evidence as it is. Therefore, you have to go through the all 161 statement of victims, other eyewitnesses, major witnesses, doctors, If he was treated as inpatient, then the doctor who treated him, then finally opinion of the doctor about the nature of injury, whether grievous or simple, all this will be available. Then the inspector or sub-inspector who registered the FIR, every 161 statement you must go through it. Then you take down the contradictions or mark down in the charge itself. Final report served with you. This all plays a vital role. Then always be very patient in a pleasing manner at the time of cross-examination of witnesses. Then other thing, one aspect I would like to discuss and share with you that before framing charge or during cross-examination, the charges are framed, three things you have to concentrate. Number one, that the charge are being framed by the magistrate if it is a warrant case. If questioning if it is by the it is a summary trial. Primary things are there, must be there in the framing of charge. Number one, date of occurrence, time of occurrence, then the facts leading to the necessary ingredients to frame the charge. If suppose 326, the necessary ingredients that the accused you on so and so date, at the time of so and so date, caused grievous injury intentionally. That is most important. So you must be very well versed with the definition classes of the offences and punishable sections. Definition classes will deals with the definition of the offence. Punishment will vary from the degree of such definition. Simple act, then grievous act, simple act by the sharpful weapon, grievous act by hands or without weapon. These things will vary the sections, gravity of offences. Or then again, diminishing of gravities may also be available, like what causing grievous act or causing simple act by sudden provocation or self-defense. So many things are there. All these things you should concentrate. Therefore, at the time of cross-examination, your mind should play very cute and accurate, so that you watch that the witnesses are speaking, are adducing the evidence in conformity with the charge framed or not. If he is not deposing, you are not supposed to put that questions and elicit which the prosecution left to, or the witnesses failed to give deposition about the particular ingredients, time of and all these things. Suppose there is variation, then you can refer your 161 statement and put without by going through the 161 statement, you can question the witness, stating questioning him that whether did you say like that. Suppose the witnesses saying that a long knife without mentioning 161 state, you can simply ask the witness, did you say that the injury was caused by long knife to the investigating officer? He may say yes or no, or I do not remember. There ends the matter. You are not supposed to show the 161 state, which is not admissible. It must be put to the investigating officer when he is in the box, that whether this particular witness deposed before you 161 statement, gave statement that the to cause injury long knife was used. So that is called a material contradiction. Time varies, material contradiction. Directions varies, material contradiction. This is most vital aspect which should be considered. You should be very calm, polite and acute in putting the questions, because some questions may be end in trouble. That all those questions are called complicated questions. Judge may also warn you. So kindly try to understand. This will be part 1. Next I will take time to again come with you. By part only you can understand. So kindly go through all my instructions, and do not waste your vacation time. Even if you are enjoying the holidays, go through the definition classes and whatever may be, not only for Indian Penal Code and also other penal offences acts. Best wishes.